Your Honor, I beg to mention item number 22.
Hmm?
Item number 22.
22.
Yes.
Yes.
I'm for the petitioner. And Your Lordship, the hearing has been completed. So this matter may be listed after 4 weeks for admission hearing.
Why? Why this is been listed for orders today?
Lordship, it was I requested for a fixed date, Your Lordship. It was a lingering for some time, Your Lordship.
So service company, you are appearing for
I'm for the respondent, Your Lordship.
respondent.
Yes, Your
Only one respondent.
Yes, sole respondent.
You are for petitioner.
Yes, Your Lordship.
On the joint prayer of learned counsel for the parties, let this matter be listed after 4 weeks in the admission column. Yes, next.
Much obliged.
Yes, Your Lordship.
May I, Lordship? Lordship, I beg to mention item number 5.
5.
Due to personal difficulties, the leading counsel could not come. The matter may be taken up after puja break, Your Honor.
Why?
As leading counsel could not come, Lordship, due to health issue.
On the prayer of Mr. B. Taipoja, learned counsel, appearing for the respondent,
Lordship.
and prayer not being objected to by Mr. L. Learned counsel for the petition. List this matter after 4 weeks.
Well, let me kindly continue interim order.
Interim order passed earlier.
Obliged, Lordship.
Your Honor, I'd like to mention item number 17 and 18.
17.
And 18.
Yes.
In 17, I am the respondent here. And in 18, I am the petitioner here. Voter analysis.
We'll see. It is listed for orders. What is to be done? You be there.
Obliged.
My Lordship,
Yes.
Lordship, I would like to mention item number 6.
6.
Yes, yes,
Hmm.
Your Lordship.
Yes.
Lordship, it is a criminal revision to set aside the impugn order.
Item 6.
Yes, yes, Your Lordship.
It's
Lordship.
civil revision.
Yes, Your Lordship.
Yes.
It is a civil revision.
You are for respondent.
Respondent number 3. Your
Yes. What
Lordship.
do you want?
Actually, I need three weeks time to file a affidavit of opposition, Your Lordship.
Affidavit.
Yes, yes.
Okay. Mr.
Yes. J. Doyam,
Learned counsel.
Jarka Doyam.
Learned counsel. Mr. So-and-so, learned counsel enters appearance on behalf of respondent.
Number
Sole
2.
respondent.
Respondent number 3.
All the respondents.
Respondent number 3.
Respondent number 3.
Yes.
And press for 3 weeks time to file response. List of prayers allowed. List this matter after 3 weeks.
My lord, I'm for the
Mr.
petitioner.
D. are the learned counsel for the petitioner is present.
Yes, my lord, there is an interim order.
Interim order passed earlier. So continue. Yes.
Much.
May I plead, your lordship? Lordship, it's an application under section 483 of BNSS. Your lordship, the allegation against me, which is in FIR, page number 18, your lordship.
NDPS.
NDPS, lordship.
Yes. Heard Mr. So-and-so, learned counsel for the petitioner. Applicant. Next paragraph. This is an application under section 483 of BNSS 2003. BNS double S. Praying for grant of regular bail to the accused. You are not petitioner. Who is the
Lordship,
petitioner?
lordship, it's the wife of the accused
Yes,
person.
accused Sri.
Midusri
Accused Sri,
Hendik. Hendik.
who is the accused?
Lordship,
Nandip Deka Burwa.
Nayandip Dekabudwa, lordship.
Nayandip Deka Burwa, alias Nayandip Sonwal. In connection with KSA/GR within bracket NDPS case number 36 of 2024. Under section 21 within bracket small b bracket close of NDPS Act 1985. Call for the case diary.
Yes.
Call for the scanned copy of the case diary. Mr. Jitado, Learned Edition PP, enters appearance on behalf of the state. Let this matter be listed after
Can it be
10
before,
days.
can it be before vacation, your lordship?
After 10 days.
Yes.
On your fixed date, give the fixed date. When? After 10 days.
I will do that.
What will be two? Third. 03010. 0310/2020.
Obliged, lordship.
Obliged.
It's not maintainable. You were granted interim bail
Exactly, ma'am.
and that has not been cancelled, that has not been made absolute.
Therefore, they should have been filed in regular. manner.
Yes,
So,
you
ma'am,
file it. Mr. C. Modi, Learned Counsel. For the petition applicant submits that he may be allowed to withdraw the present bail application with the liberty to file fresh.
Right.
This time. Where is allowed? With a liberty to liberty as spread for, Bail application stand this closed.
May I please, your lordship?
Yes,
Lordship, this is an application under section 528, read with 438 BNSS for quashing of FIR, lordship. Lordship
Yes.
will find FIR at page 15, lordship. This FIR is lodged for recovery of money, lordship.
what is the
Lordship, allegation is that the informant invested in an online company on the advice of the petitioner, lordship. And now he is seeking recovery of the money from the lordship petitioner. Lordship will find the FIR at page 70. FIR, I need return back money from Ekubali. Ekubali is the petitioner, lordship.
you are Amrudi Ali,
I am the Ekubali. Amruddi Ali is the informant, lordship.
you are the accused.
I am the accused, lordship. I have come for quashing, lordship. Because he has the civil remedy, lordship. He has the civil remedy to recover money, if any, lordship. I have annexed the order of Honorable Apex Court also, lordship. Apex Court observed that police
Okay,
have-
David, we'll come to the ethics court, the case law letter. Let her understand what is the allegation against you.
lordship.
Yes, what is the stage of investigation?
Lordship, it is investigation stage, lordship. Police is investigating, lordship. And
You
all
have-
the
Yes, mister, you have lured the informant to invest money and then you just disappeared.
all these account numbers are not belonging to me, lordship. You will find that names of the
It's
account
not a
numbers.
civil dispute. Yes, mister, it's not a civil dispute. There's no transaction, business transaction. You have lured him.
Lordship, this all account numbers are this company, not a single account number. He has transacted money to my account.
Just issue this, that's all.
Lordship, kindly proceeding must be stayed, lordship.
Are you admitting that
I
You have
advised,
wrong.
I advised him to invest, lordship, but I did not take any money from him. Lordship. I advised, this is admitted, lordship. He took advice from me, lordship.
Mister, did you receive the amount from the
I-
informant?
No, I did not receive lordship. This amounts are transacted to this account number.
Where are you
mentioned.
now?
I'm in Assam lordship.
Where are you now?
I'm in
You
Assam
come here
lordship.
and pay back,
Some protection lordship. I
or else will direct the police to arrest you.
some
But
protection law.
how you can easily say so that this is a civil dispute? How can this be a civil dispute?
As per his claim lordship. He's claiming from me lordship.
You read the FIR.
Lordship.
Just saying that you're saying will not do.
So I need return money back from Echo Valley. Lordship.
Yes. You are missing now after
Right.
receiving the amount.
His prayer is lordship. I need back money from the Echo Valley. Echo Valley is the
Forget about, don't read one line. Read the
Yes.
entire contents of the FIR.
lordship.
Details have been given. Are you working here?
No lordship. I'm in Assam lordship. In Borpeta lordship.
So you pay back.
I had contact with him over telephone lordship. When
Yes.
he over to telephone only. He is also a resident of Meghalaya permanent
Meghalaya.
lordship. I'm the
Where are you?
permanent
You are from?
Assam lordship.
You?
I am from Assam. Petitioner from Assam. Informant is from permanent resident from Meghalaya.
You are, no, as a learned counsel, where you are appearing from?
I am from Guwahati lordship.
Are you appearing from Guwahati?
Guwahati lordship.
MK Hussain?
MK Hussain lordship.
Are you MK Hussain?
Lordship. Lordship.
Yes.
Since it seems investigation is not yet complete. So
We'll call
call for CD.
Heard Mr. MK Hussain, learned counsel for the petitioner. By filing this application under section 528, read with section 438 of BNSS 2023. The petitioner has sought for, has prayed for quashing of the criminal proceedings, quashing of the FIR and consequential proceedings being Naharlagan PS case number 81 of 2024 under section 420 IPC. Call for the scanned copy of the case diary. Jita, London, additional PP appears for the state. Miss matter after 3 weeks.
Yes, obliged.
Yes, sir.
Lordship, this joint convenient petition is filed under section 482 under bracket section 528 of BNSS, Your Lordship. So Lordship, this application, that's a party, this petitioner number 1 is complainant and the number 2 is the accused person, Lordship. And on being a settlement, this application is filed.
Art Mr. Swenso, Land Council for the Petitioners. This is an application under section 528 of BNSS 2023. Who is the accused? Petitioner number 3.
Petitioner number 2 in lordship.
Okay. 2023. Bring for enforcement of the criminal proceedings of DR case number 36 of 2005
Yes, lordship.
and the section 279 oblique 33 337 of IPC read with section 182 of Motor Vehicles Act 1988 pending before
This learned CGM.
which
Matter is pending before this Chief Judicial Magistrate UPR.
pending before the CGM, UP on the basis of compromise,
Compromise.
on the basis of settlement between the parties. Call for the scan copy of the trial court record from the from the court of CGM, UPA.
Lordship, an interim, this
Pending
proceed maybe.
production of Johnson, the proceedings of DR case number 36 of 20/005 so remains suspended. This after 4 weeks.
Much of that.
Seven. I think no one appeared for the petitioner.
Is your lordship. I'm appealing for the petitioner.
See, it's very difficult. Yes,
Lordship, I am appealing for the petitioner.
yes, proceed.
Lordship, this is a criminal petition which we have filed for setting aside and quashing. The
Yes, right.
cognizance order taken by the London lower court, and the interim order is at least 42, Lordship. In an NI case proceeding, Lordship. Wherein
Page?
is 42, Lordship.
42.
Yes,
Yes.
Lordship.
Hmm.
So we'll find that the offences to be committed has been mentioned under section 138 and read with section 142. And in total numbers of 5 checks were dishonored by the bank. And thereafter, the respondent, after getting the checks dishonored, had issued for 5 checks in total, had issued 2 numbers of legal notices, Lordship. And thereafter, after issuing of the legal notices, the respondent have filed a complaint petition against the petitioner, and the London lower court had taken provisions by this order. Now, Lordship, when the London lower court had taken provisions, there was a violation of section 138 as well as section 142 of NIA. As to how, Lordship, the legal notices were sent beyond the statutory period of 30 days, which should have been within 30 days. Thereafter, also in the complaint petition, it does not reflect as to on which date the legal notices were received by us, or whether they were received or not. Now, Lordship, also the complaint petition should have been filed within 45 days, but that is also out of limitation. Moreover, Lordship will see at case 43. Case 43 in last para, since it has been mentioned that since the complainant is not present today, matter is adjourned to 22/5/2019 at 10 hours for recording of statement of the complainant and witness, if any, under section 200 of CRPC. However, in order to expedite the trial proceeding and being the instant case is of summary procedure, complainant and witness, if any, may like to submit their statement in affidavit form on or before next date fixed herein above. Lordship, even before recording 200, admittedly, even before recording 200 CRPC statement or even taking the same on affidavit, the London lower court had taken the cognizance of the case by disorder, which could not have been done under section 200 CRPC Lordship history. As such, we have challenged on all these grounds this impugned order, Lordship, where also the impugned order does not reflect whether the complaint petition has been filed within limitation period, whether the legal notices have been issued within limitation period. So those parts have also not been dealt by the London lower court in the impugned order laws. As such, on these grounds, we have sit for setting aside the impugned order.
That's all. That's all.
Yes, Lord. These were the three grounds where we have on which we have filed this criminal petition.
See, Mr. It's very difficult for BC. I'm not getting any. I mean, I could not make out anything what you have submitted.
So, Lordship, then the matter may be adjourned to any other date. I'll be personally appearing before the Honorable Court.
Because it may lead to miscarriage of justice. I don't know whether you are comfortable or not. At least this court is not comfortable.
Then matter may be listed on any other day.
So these are only your submissions.
No, Lordship, if I am not clear, Lordship, the matter may be adjourned for today. May be fixed on any other date, Lordship. I'll be personally there to appear. Today, due to inconvenience, I could not appear personally, Lord.
It's okay. If you have nothing more to submit, we'll record it and we'll decide the matter.
Lordship, kindly, the matter may be adjourned. I'll personally appear, Lordship.
Then you have argued. You complete it, we'll dispose of the matter.
Lordship. I'm audible.
What do you say?
My lord, there were 5 checks. All 5 checks bounced. And legal notices, 2 legal notices were issued.
Any objection?
My lord, since this is completely based on records, because I have not filed my objection.
No, whatever is there.
Yes, my lord, only the law point and the facts only. Facts are not disputed, law points are also not disputed. Now, this first check and the second check were issued, the bouncing was on 22/1/2019 and second was on 16/2/2029. We have served the legal notice on 22/2/2019, that is within a period of 1 month. And my lord, serving of legal notice under 138 is also a prerequisite to initiate the proceeding. And if it is filed within 1 month of period, then my lord, this 30 days requirement from the bouncing, my lord, this issuance of check, issuance of legal notice is also a continuation of the course of action. 142(2)(a) says that the period shall be counted from the day when the course of action has arisen. And then bouncing is one. Serving of legal notice, which is a prerequisite under 138, is also another course of action. And this course of actions, we have to see whether the legal notice was served within the period mentioned under 142. And if it is within the period of 30 days, then my lord, initiation of 138 proceeding is covered. There is no bar in that. So only this has to be pointed out, as your lordship has also pointed out. If at all Mr. is unable to present, let this case be listed day after tomorrow. I will come with all my.
Yes, day after tomorrow.
Lordship, I am appealing from Tinsukia, and Lordship may adjourn the matter after the puja vacations, Lordship, because it
No,
will be
no.
very. I'll be also. I'm scheduled to be in the All Assam Lawyers Association meeting at Patsala, Lordship, in between. So, Lordship,
Tinsukia is only 4 hours drive.
absolutely, absolutely. Lordship, I'm scheduled to be there at Patsala from tomorrow, Lordship. Patsala district.
But since your lordship has heard so much of this,
No, it's very difficult because it's not comfortable to BC.
Mm.
In fact, he has just narrated the facts only of the case. He has not.
in that case, my lord, I will also submit gist of the case, my lord.
It's better.
My lord,
Not necessarily affidavit in opposition, yes, just kind of reply. That will be
yes, my lord.
more easier for the
Yes.
court as well as.
With the list of dates and
Yes. Okay, heard Mr.
D. Mishra, Lordship.
B. Mr. Learned Counsel for the petitioner, and also heard Mr. T. Patil, Learned Counsel for the respondent. On the prayer of Learned Counsel for the parties, let this matter be listed after puja vacation.
blood puja vacation. Then in that case, if not on 3rd or 4th,
3rd or 4th
4th,
October.
4th
3rd
of October will
October.
do, Lordship.
3rd
3rd October will do, Lordship.
3rd of October.
Yes, Lordship.
For disposal, better you should present personally here, physically.
Sure, Lordship.
3rd of October, 2000.
Obliged, Lordship.
obliged.
My lord, this is a application for quashing of the NI proceeding under 138 pending
Yes.
before the GMFC court,
Hmm.
UPI.
Your Honor, I kindly beg to submit that the leading counsel for the respondent is out of station, Your Honor.
Heard Mr.
T. Sunil.
This is Learned Counsel for the petitioner. Mr.
A. Gamle.
Learned Counsel for appearing for the petitioner. Submits that leading counsel, Mr.
I'm for the respondent, Your Honor.
Huh? Oh,
He's for the respondent. I'm for the-
correspondent, huh? Mr. So Learned Counsel appearing for the respondent submits that the leading counsel, Mr. B. Jamo,
Yes, Your Honor.
Learned Counsel for the respondent is indisposed today, for which he pressed for listing the matter after 3 weeks.
My lord, can it be listed on Friday? This matter is pending since 1 year. And there is nothing much to submit also.
Have you seen other the cause list? Some matters are pending 2012, 2015,
This,
16,
this matter will hardly take 10 minutes.
according to you, but this court has to decide. It's easy for the lawyer, but difficult for the judges. We'll have to decide.
In that case, my lord, it's
When?
short date can be given.
When?
After 1 week.
2 at least, Your Honor.
It should go to after vacation.
It's okay then
After
after vacation.
Much obliged.
May I please, my lord? This matter may kindly be, my lord, posted after vacation.
It's better. It's better.
I was busy
No,
in some
no.
other matter.
No ground for quashing.
Lordship, there is interim last occasion, without hearing my submission. The Honorable
What
Court has-
interim?
Lordship.
What interim?
Uh,
What is the stage? What is the stage?
For the charge, consideration of the charge matter is fixed. Because,
Okay.
Once, if it is not listed, then this matter will become infracted. That's why, my lord, because after vacation, this matter can be listed, then it can be.
No, Lordship,
Till
I'm-
that time, my lord,
Lordship,
it will be continued.
I object to the
adjournment.
Hmm.
Lordship, I'm with great responsibilities. I'm submitting that the way, the manner in which the learned state public prosecutor is conducting this case is not appreciable. And in
Who?
the learned state
Me.
public prosecutor, no. The learned state public prosecutor, because last occasion, only on the basis of his submission, the stay was granted.
State public prosecutor.
State public prosecutor,
Who?
public,
Who?
J. Since the day one, the way, the
Sir,
manner
you are
in which
making a
this-
serious allegation
I'm
against your
with
colleague.
responsibilities, I'm
Ac-
submitting this.
against your colleague, who is the public prosecutor of this state.
Lordship, I'm with great responsibilities because this is not.
File an affidavit in that.
I'll file.
File an affidavit.
I'll file.
If you,
Lordship,
are you,
I'll
if
file.
you are you serious?
Yes, I'm serious because I'm.
See, you have to
accountable to
realize
my-
you are making an allegation against
Lordship,
the
I'm-
public prosecutor.
Lordship, with great responsibilities, I'm making this submission because from the day when this matter was listed for anticipatory bail application, since then, the way, the manner in which the public prosecutor is conducting this case is not, because last occasion also, he has not submitted full fact. Only after his submission, the Honorable Court has granted the imprint. It is not appreciable, and I'm with great responsibilities, I'm submitting.
See, you should realize the public prosecutor. I'm not saying that you don't have this status. It stands, he has some responsibility.
Lordship.
But
Lordship, I
he's not
accommodated.
I mean, kind of normal kind of practicing lawyer. He has that responsibility.
Lordship, only
Therefore,
with
if you
respect,
have that allegation, you have to file an affidavit.
only with respect to this case, I'll file a affidavit.
Are you sure?
Yeah, I'll file affidavit
See,
because with great
it's-
responsibilities,
As
otherwise
they
I
say,
would have,
it's very easy to make an allegation.
Lordship, I'll file with record. From the day when the anticipatory bail was moved before this honorable court.
My lord,
The way how this case has been conducted by the public prosecutor, because even the victim who is suffering, a lady, I'm accountable to her. And she is vigilant enough.
Everyone, not only you, he also accountable.
I'll-
The court is also accountable.
Lordship,
The public prosecutor is also accountable.
Lordship,
Everyone is accountable.
for which I'll file affidavit with record. This I'm submitting with all responsibilities and with record. I'll file affidavit.
Then my lord, even anticipated bail after hearing, because the submission by either of the party is not binding on the court. Court, after praising the FIR, after in the bail order also, my lord, has gone comprehensively about all the materials. And considering the fact, my lord, where is the question of 370? Tomorrow even, my lord, even my learned friend praise. This is not the case how, this is rather the abuse of the process of law. My lord, the judgment is very clear. The settled proposition of law is very clear. A man and woman after living openly for 7-8 years, thereafter you will come and say, no, my consent was taken by misrepresentation, my lord. This is not done, my lord. There is, in anticipated bail,
But in any case,
Lordship,
it's
I have
not a ground for quashing.
Lordship, I have not submitted on
May
merit.
not be, may or may
my
not
lord,
be.
my lord,
The trial is- the trial has to go.
of course, that call my lord will take, my lord. Then, my lord, after vacation,
But
my lord,
another aspect is making a very serious
Yes,
allegation
Lord.
against
Lord.
PP.
Lordship, I'm not on merit. What I'm submitting is the way, the manner in which the case is being conducted, because I'm just assisting the PP. Lordship, just on anticipatory bail,
No,
Like-
this is what? This is the criminal petition. It's a
Lordship, this
criminal
is,
petition.
yes,
criminal
this is for
petition.
quashing
You are a
the-
party.
I'm
Yes,
fine.
You have the right to, you don't only have to assist the PP. You have an independent right to defend your right.
On that account, I'm presenting victim at the same time because PP is representing the state.
But then you have stayed for so many years and suddenly when there's a
No,
difference.
state was in last occasion only.
You,
Because court had last occasion.
no. Both of you were
More than
stayed
7
together
years.
For 7 years.
Lordship,
Husband and wife.
Lordship, there is not only the one count. One count is there.
And fine,
And
but-
other count,
And after 5, 6 years, when your relationship is not palatable or you are
Cannot-
having a difference, how can you just say that I've
Lordship,
been raped?
Lordship, on merit, I'll submit. However, now I'm not on merit because as
let him come on affidavit
I'll
about all
come on
those
affidavit.
allegations. My lord.
With record, I'll come on affidavit.
This
I'm submitting this with great responsibilities.
Or Mr. Arsona counsel for the petitioner. Mr. Arkoyu, learned counsel for the respondent. Submits that has made serious allegations against the learned public prosecutor, Mr. Singh,
Yes, Jesse.
about his conduct in this proceedings. Mr. Mr. Arkoyo, despite the suggestion by this court, has stick to his allegation by submitting that he's making the allegation against the learned PP of the state with full responsibility. Mr. In view of the above, the Mr. Arko learned counsel for the respondent number 2 is directed to file directed to bring on the allegations directed to file an affidavit by bringing the allegations against the learned public prosecutor. Mr. What is the allegations?
Lordship, from the day one, if I count, Lordship, they moved the bail application on to 31st July 2024, 2023. Lordship was there.
See, I'm not. It's a kind of warning. You take it. If we find something, I mean, not if we find that your allegations are not, I mean, if there's no allegation, if there's no substance in your allegation, it may rebound. See, the public prosecutor, for that matter, every lawyer, you cannot appear before the court mechanically. Certain cases you'll have to concede in accordance to the law, maybe subject to, because as a lawyer, you're the officer of the court. It's not only your cases, for the heck of defending, you are not supposed to. That is at least this court believes. So if we find on your affidavit, if we find no substance, then it may rebound you.
Lordship,
Think about it.
my allegation is even
Just because there was a bail was granted, just because there is stay order passed by this court.
No, Lordship, not only on, not because of that, because I'm waiting this case for since last 1 year.
Waiting is something different. Just
No,
because it
no,
case is
and
not
Lordship,
taken up, you
Lordship,
just cannot make an allegation against your colleague.
Lordship, the way he presented the case, last occasion, he has not disclosed the full fact. He stick to the rape allegation wherein accused find favor. What about the other count? There is other count. He stick
Sir,
only.
you are a young lawyer.
No,
That's why I'm just indicating you.
Lordship, in that case,
Tomorrow it may happen to you also.
I'm
not saying that your conduct, but if you have a serious allegation, if you said, then we'll take care of, because we have to clean the system.
Lordship, because
We'll clean the system.
as repeatedly I am submitting, because I am accountable to my client who is the victim. So,
I
Lordship,
have said everybody is accountable, right? You are making an allegation against the public prosecutor of the state.
Lordship, in that case, let the matter be heard, and I'll submit the fact only how this has been carried out. In that case, the
Sir, I have given you enough indication. It's okay. Mr. T. Learned Edition PP is present. Why he is not appearing?
So I don't know, Your Lordship. Maybe other issue, not for this case, Your Lordship. Now the case in projected in that in a way that.
Then let this matter be listed after vacation. Did you
Because
find-
18th, the before learned trial court, it is fixed for CC 18th October.
Can't help it. Did he stay?
File IA
Yeah,
order for vacation of the stay order also.
In the time the final proceedings is in the running with the
File 9.
Because last occasion, it was the consensus decision. I thought like today, the matter will be heard and Lordship, since the day one, what I'm submitting is I may not have the
No,
case.
I'm ready. This court is ready. Problem
My
is
lord, my
your
lord will
friend.
see all the records. This is the first time I am taking adjournment. My learned friend had taken adjournments so many times. If I see the record.
Lordship, that is, Lordship,
Now, my
I can
lord-
furnish the record because that is available on
my
record.
learned friend has to know, DP is not there to only say against the accused. If something favorable is there in favor of the accused, he has to tell. That is the, my lord, law of the, that is the law, my lord. It is not something, my lord, something favorable there in the accused. DP cannot, that is not the law.
Okay. List after Puja.
My
File the affidavit.
I'll file it.
Mind you,
I'll file it.
interim order may be continued till then.
interim order passed and they shall continue.
Thank you very much.
My lord, this is regular first, second appeal, my lord.
Yes.
Against the judgment and order passed by the learned civil judge Senate division Pasighat. My lord, the appellant.
Well, issue notice.
My lord, since there will be execution of the judgment and order passed by the learned civil judge, my lord, that might be stayed, my lord.
Where is the substantial question of law?
That is, my lord, that my lord, while passing the judgment or order, my lord,
Yes.
the learned civil judge Senate division has almost consent to the submission of the appellant, my lord. But then, my lord, what he, my
Where-
lord,
Where it is?
see, my lord may kindly come to. My lord may kindly come to page 40. What happened, my lord? When the first appeal was filed before the learned civil judge Senate division Pasighat, my lord, he ought to have tried the matter de novo. It's because in the cover proceeding, my lord, which was impugned in that first appeal, there was no evidence was taken, my lord. No evidence was laid by either of the party, my lord. Only on the submission statement made by the complainant, my lord, the husband, my lord, of the appellant, Kaba has decided the case in favor of the respondent. My lord, may kindly come to this para 29 of the judgment and order passed by the learned civil judge Senate division, my lord.
Where it is?
It is page number 40, my lord.
40.
40, para 29. In the light of the argument advanced by both the parties, it is to mention that the subject matter of Kaba, as is seen from the Kaba Parwana summons, was regarding the matrimonial discord between both the parties, and the complaint was filed by Mr. Lidor Allen against his wife, Ms. Georgie Muba, who wants to divorce him due to her illicit affair with one Koki Ken. Now, my lord, where the mysteries of justice is exposed, my lord. The issue of physical is so, my lord. I will be confined to this sentence only, my lord. My lord has seen the complaint was filed by the husband, the respondent, my lord. But while passing the Kaba decision, my lord, the appellant was made to pay an amount of 6 lakhs rupees to the husband of the appellant. Because, my lord, there is a custom in Galo, my lord, and book has been published regarding this to resolve this matrimonial dispute and all, my lord. Although it is not codified, my lord, this is being adhered to by the Galo denizens of the state, my lord. In Bogum Boka Taba, what it is provided in Bogum Boka Bo, that the person who wants to get divorced will be made to pay one mithun to the other party. But here, my lord, has seen it is the husband, my lord, who has lodged the complaint before the Kaba, my lord, who wanted to get divorce from the appellant. But Kaba, instead of imposing fine on the respondent, has directed the appellant to pay 6 lakhs rupees to the complainant.
You don't want to pay.
I don't want to pay because I don't want to get divorced. It
You
is
You don't want to divorce.
Yes, my lord.
But
So-
you are involving, you are not, you are not maintaining.
That is true. That was, of course, disclosed the unfaithful act by the appellant. It was disclosed to the defendant. And after disclosing also, they were living peacefully together for 3 months. But after that, the husband started inflicting atrocities to the appellant, my lord.
Okay.
And this, in any case, my lord, the legal point, my lord, which need to be appreciated,
Yes.
is that the complaint for the dissolution of the marriage. It was filed by the husband, respondent. So if he wants to get divorced, it is he who ought to have been made to pay the penalty, my lord.
Keba has directed for, decided for divorce,
No,
granted divorce.
no, not divorce. Kaba has never decided regarding their matrimonial
What they have decided.
status. Kaba has decided that
You should live,
no,
continue to live as a husband and wife.
no, that too also Kaba has not decided. Kaba has decided that the husband has spent that much of money for this
Wife.
the appellant wife. So this
So she has to pay
yes,
6
yes,
lakhs.
this fact it was
What is
appreciated.
what is the Keba actual decision? What is the actual decision?
Actual decision that Kaba has imposed 6 lakhs.
6 lakhs
Yes,
and separated.
not separated. 6 lakhs only. 6 lakhs, and they have said nothing about this our continuance of our relationship as a wife and husband.
Where are you
But-
now? Are you living separately?
We are living separately, but there is no judicial order as such that, by which we are living this separately. Now, my first,
Do you have children?
my lord,
Do you have child?
no, my lord. I do not have, my lord. Now, my lord, another thing, my lord, the ground I have taken in this second appeal is that, my lord, both the husband and wife,
Actually, whether you agree to it or not,
my lord,
that the husband has spent this much of amount on you.
this, my lord, this fact, my lord, let me clarify, my lord. This fact, of course, my lord, no, I am not agreeing that, my lord, he has spent that much of
What do you want now?
I wanted, my lord, the customary law of the
What
Gala
is
should be
customary?
privileged because that aspect has been appreciated correctly by the learned court below. But then what? Instead of this sticking to the,
Who will file the first appeal?
my lord,
By respondent.
no, by the appellant, present appellant.
First appeal.
Yes,
Okay.
that, my lord, make kindly appreciate.
You have filed an appeal against the Keba decision
Yes,
of
my lord.
imposing 6 lakhs rupees
Yes, my lord.
to be paid to the
Yes, my lord.
respondent. Against
ground
that,
taken by-
you filed an
Yes.
appeal before whom?
Before the civil judge, senior division, Khasigat, my lord,
Okay.
because it's come.
Then that is the order of the appellate
My lord.
court is unchallenged.
Yes, my lord. the order of the first appellate court is under challenge now.
Yes, what's wrong?
The wrong, my lord, firstly, my lord,
Hmm.
I have raised the issue of jurisdiction, my lord.
Hmm.
And it is admitted fact that, my lord, the appellant, present appellant,
Have
and
you raised it before
the husband, my lord.
First
Eh,
appellate court.
My lord,
Did you raise that issue?
yes, my
before the
lord.
First appellate court.
It was raised.
What's the jurisdiction issue?
Instead of this objection, my lord, Keba proceeded. That is, therefore, my lord, they proceeded the Keba.
What is the
Keba has come to the conclusion
what
that
is the jurisdictional error?
jurisdiction error is that, my lord. Me, the appellant, and my husband, they are from Sivaratar circle. Of course, they are from different villages. So my first objection was that, as per section 19 of CPC, my lord, the case at this shoot can be instituted where the defendant resides or where the cause of action has error. Now, defendant resides within Sivrata circle, my lord. And myself, the appellant, he is also from Sivrata circle. There are two circles in this Gesi area, my lord. First one, Gesi circle is there, my lord. And another is Sivrata circle. It is more interior place, my lord. Now, this Kaba, my lord, that was Bengal level Kaba. Even we have raised objection that in the very proceeding. No, the village level Kaba has to decide this issue. Village level Kaba.
But Bengal level.
Not Bengal level. Now, my lord.
No, which Bengal level? Is it your
No, my lord. That is
Bengal?
the error, my lord. From the very beginning itself, my lord.
Which Bengal?
We are from Sivrata Bango, my lord.
Yes.
Sivrata Bango.
So what which Bengal has decided?
Yes. Why?
Which Bengal?
Gesi Bango, my lord.
Okay.
This is different Bango, my lord. Neither I belong from that jurisdiction nor that this respondent, my lord. We are from Sivrata, my lord. There is separate Sivrata Bango, my lord. There is separate circle head gum of Sivrata area, my lord. This case, my lord, could have been decided by the Sivrata Bango, my lord. Is therefore, my lord, from the very beginning itself, this Kaba decision is wrong, do not have the force of the law, in fact. Therefore, my lord, this issue was raised before the first appellate court also, my lord.
Hmm.
Now, my law for it is that, my lord, on which ground, my lord, I am challenging the decision of the learned court below is that, my lord. Firstly, I have raised the issue of jurisdiction, my lord. That ought to have been, my lord, appreciated by the learned court below. Because it is admitted that, my lord, both the parties, my lord, the appellant and her husband, they are from Sivrata Bango. So it is only the Sivrata Bango, my lord, who could have adjudicated this case, my lord.
Hmm.
Secondly, my lord, as per Bogum Boka, my lord, which is being followed by the Galo diligence of the state, my lord. The person who was to get divorced.
It's not a following, just not following. Is it a accepted customary practice?
Yes, my lord. That, my lord, and my lord, one thing more, my lord. This aspect, my lord, it has been correctly appreciated by the trial court below, my lord. Despite appreciating the fact and considering to the privileged customary law of the Galo, my lord, he has passed the judgment on only presumption and services, my lord. What she says, my lord, while passing the judgment.
Appellant. Decision appeal under section 100. Read with ordered 41, 42.
42, my lord.
Within bracket, within 42 within bracket 1, not 42. Rule 1 of CPC 908. Challenging the impugned judgment and order dated 26/07/2024 passed by the civil judge within bracket senior division Pasigat in civil appeal within bracket Keba number 142 of 2023. Whereby the appeal filed by the appellant has been virtually allowed. By setting aside the point number 1 and 5 of the Keba decision dated 27/10/2022. And affirm affirm the point number 2 and 3 of the decision. By which an amount of rupees 6 lakhs has been imposed by the Keba to be paid to the respondent for the expenses incurred on her during the marriage, during the currency of their marriage. During their marriage and as compensation for her conduct. So bracket close. Issue notice to the respondent returnable by 4 weeks. The learned counsel for the appellant to take a step for service of notice upon respondent number 2 by register for censure. Next, madam. Considering that the issue of jurisdictional error has been raised by the petitioner to the proceedings of Keba as well as the impugned judgment and order dated 26/7/2024 by the learned civil judge within bracket senior division Pasigat in the interim the order dated the judgment and order dated 26/07/2024 is stated till the returnable date.
My lord, since the defendant, my lord, respondent has filed the execution petition and notice.
Where do we state?
Yes, my lord.
Where we state?
My lord.
Since the interim order is passed, next para, in the absence of the respondent may file appropriate, may approach this court by filing appropriate application for modification or vacation.
Much
after 4 weeks.
Much obliged.
May I please, Your Lordship?
Yes.
Your Lordship, this is a criminal petitions filed by the complainant along with the accused person for quashing the criminal proceeding, which is pending before the CGM 0. Here in this case, Your Lordship, the allegations of an FIR
Yes.
Here is the allegations in the FIR arise from an incident involving the breaking into the complainant's mobile shop and stolen away the mobile handset, Your Lordship. However, Your Lordship, they have settled the matter outside the court, Your Lordship. And they make case settlement deed, Your Lordship. Kindly see the page number 108, Your Lordship. This is the case settlement agreement.
Let us see the FIR first. FIR and the charge sheet. Is it been charge sheeted?
Yes, it's charge sheeted, Your Lordship. They have not annexed the FIR.
There's no FIR.
You also see it's what happened in this in this situation. Your Lordship, during the course of the proceeding, Your Lordship, it came into light that FIR is not included in the petitions. Your Lordship, at the time of filing of this petition, Your Lordship.
Charge sheet is in page number 40, Your Lordship. The operating part, the brief of the case. 40. Only for quashing of charge sheet, not the FIR, perhaps, Your Lordship. In the prayer also. They have to pay for quashing of the FIR as well, Your Lordship. It's only the quashing of charge sheet, Your Lordship.
Your Lordship, the dispute between the parties is purely for personal, Your Lordship, in private in nature, Your Lordship. Therefore, Your Lordship, the complainant has voluntarily agreed to settle the matter and withdraw the charges. Therefore, we make the mutual settlement, and also we paid the compensate amount, Your Lordship.
Where is the settlement?
It's Lordship, page number 108. I have the original copy. If this honorable court wants to see,
Which one?
there's a mutual settlement deed, and also I have the money receipt also.
What is this?
This is original copy of
This
the
is the original
settlement
copy
deed.
of the settlement deed.
What's so seclusion about the original? It's legible, it's all right. Yes,
Your Lordship. If they have settled the
but
matter.
appears to be you are a gang.
No, Your Lordship.
Accused that a gang.
This is the first time we have been involved in such a case here. No criminal records has been pending. to find-
Caucus. not only gang, caucus. How old you are? I mean, the accused. 18 years, 25 years.
19 years.
19. In the age of majority.
You are not matured enough to be the member of the caucus also.
Please, regarding the case, Your Lordship.
It's okay. Yes. What is to be done?
Lordship, since they have settled the matter, is a remote and bleak chance of conviction. They, so far as Your Lordship, the allegation is concerned is 380 theft. In many occasions, Your Lordship, this court has quashed the same similar situated case, Your Lordship. I will leave it to Your Lordship this question.
Art, Mr. What's your name?
Tigame, Your Lordship.
Learn the counsel for the petitioners. Petition application under section 482 PRPC. Jointly filed by the complainant and then accused. Accused within bracket S. Bracket close. Praying for enforcement of the criminal proceeding of GR case number 28 of 2020 under section 457, public 427, public 380, public 34, IPC 1860. What is the charge sheet? Charges?
Section 480, 427, and 457.
Just wait. 423, on the no, pending before the
CGM 0.
Chief Judicial Magistrate, 0, on the basis of the settlement between the parties. Next, the case set up by the prosecution in brief is that on 29/05/2020 at 17:48 hours, a written FIR was received from Sri Hibutana within bracket petition number 1, bracket close, of Hong Village, 0 district, 0 Lower Subaltern district, to the effect that on 29/05/2020, in between 0200 hours to 0300 hours, within bracket night, some unknown miscreants had stolen our commodities of electronics located at main market, Kapoli, by breaking the part of wooden door. It is alleged that the miscreants have stolen mobile handsets and other electronics devices of what rupees 1 lakh. List of page 40, first para. You just said the list of stolen items are as follows. Huh? Next page. On receipt of the written FIR, a case was registered being 0 PS case number 0017 of 2020 under section 457 public 380 IPC. List of next paragraph. After completion of the investigation, the police has filed a charge sheet which date on 15/09/2021 under section 457, 427, 380, public 34 APC against that petition number 2, 3, 4 and 5. How many accused?
Four.
4 accused.
Yes.
4 and 5. What is the stage of the
CC.
CC?
Yes.
List of the stage of the proceedings is consideration of charges before the Court of Civil Chief Judicial Magistrate 0. In fact, you have confessed, admitted, of course, before the police. All of you have confessed that you have committed a theft or you have stolen all these properties and sold it.
Your Lordship, we only,
And
only give 161
Yet you
statement.
have earned handsome amount by selling all this.
Your Lordship, we have paid the amount also, Your Lordship.
Huh?
We had paid the amount also.
That will not absolve.
If you see the
Next
page number
paragraph.
111, Your Lordship.
Mr. So and so, learned counsel for the petitioner submits that during the pendency of the criminal proceedings, the complainant complainant, the petitioner number 1 hearing and the petitioner number 2, 3, 4 and 5 have entered into a deed of mutual settlement on 03/10/2023. Mr. The agreement have been entered by way of reconciliation meeting between the parties involving, by involving all the family relatives of both sides at 0. Thereby amicably resolve the amicably resolve the matter and decided to maintain a harmonious social relationship between the parties. Therefore, he submits that since the parties have settled the matter and settled the matters and the petition number 1, petition number 2, 3, 4, and 5 being of young age of 18 to 19 years, 18 years to 25 years,
23 years.
23 years.
Yes.
The proceedings of GR case number so and so, may be quashed. He further submits that in view of the settlement between the parties, there is no chance of conviction. The chances of conviction are bleak and remote. He submits that since the petition number 1, 2, 3, 4, and 5 are of very young age, the quashment of the present proceedings will ensure the reformation of the will ensure their reformation in future. And as such, he submits that the criminal proceedings, present criminal proceeding, their case so and so may be washed. Next paragraph, Mr. So and so, Mr. T at the learned additional BP. Clearly submits that since the accused are of very young age, and parties have settled the matters, he has no serious objections for quashing of the criminal proceedings as it would help their reformation. However, he submits that this court may take into account the relevant provisions of law. Relevant provision and pass the relevant provision of law and may pass appropriate orders as it deemed fit and proper. Next para. I've considered the submissions of learned counsel for the parties. And also, there is the trial court records. It is noticed that no, it is not. No doubt there was a the on consideration of the materials, it appears that some unknown miscreants, that some miscreants have stolen certain commodities from the electronic shop of the petition number 1, located at main market at Hapoli. At main market, Hapoli. Mr. During the investigation, the petition number 1, 2, 3, 4, and 5 were arrested. It is also seen that the petition number 1, 2, 3, and 5 had admitted before the police that they have stolen the articles by breaking the shutter of the shop of the petition number 1. Thereafter, they sold off the articles to a different consumers. What is that admission, confession in the charge sheet?
Yes,
It's in the 161.
161.
Yes, Your Lordship, it's a part of the charge sheet.
Next bit. The police has filed a charge sheet against the petition number 2, 3, 4, and 5 under section 457, 427, 380 of 22, 380 of 34 of IPC on being found well established against them. Next paragraph. During the pendency of the trial of the case before the London Chief Judicial Magistrate at 0, the parties have entered into an agreement on 03-10-2023. So as to maintain a harmonious social relations between them. The settlement has been arrived with on the reconciliation process by the family relatives of both the informant, both the complainant and the accused, who have joined as a petitioners in this present proceedings. Next paragraph. Having considered the materials and considering that the parties have settled the matter on the intervention of family members for maintaining harmonious social relation between them. And considering that not once, comma. I'm of the considered view that the continuation of the present proceedings would not serve any purpose, rather would be an abusive process, as the parties have settled the matter. There would not be any the settle the matters. The chances of conviction appears to be remote. The next paragraph. The other aspect of the matter which this court deem it appropriate to consider is that the accused petition number 2, 3, 4, and 5 are young as of 18 years to 25 years. You just, that's not 23. 18 years to 25 years. If what is that? Young age of 18 to 25 years. Come on. The settlement of such matter may help them to reform themselves in future. Next page. In the so-and-so, the Honorable Supreme Court in the so-and-so case, in this so-and-so. Next page. Considering next page. In view of the above, in view of the discussion made here in above. I am of the considered view that the present case is one of the cases where the inherent power of this court could be exercised. Accordingly, the criminal proceedings so-and-so, so-and-so, pending before so-and-so, hereby set aside in cost. The criminal petitions is allowed in this one. Yes.
Obliged. Much obliged, sir.
Lordship, I am for petitioner in this matter. Petitioner Salil Pandya.
Yes.
Lordship, this is application under section 5 to 8 of BNSS for quashing FIR number 74 of 2024, dated 15th July 24 under section 318 of BNS, registered at PS Naharlan. Lordship, respondent number 2 wants to convert purely civil disputes into criminal cases by lodging this FIR and entangle the petitioner in a criminal prosecution just to settle his desired goal. Actually, petitioner and respondent 2 both are traders and doing business of steel kitchen equipments, and both have been doing business with each other since 2019. My lord, in this, the allegation is FIR in which respondent number 2 paid actually 9 lakh rupees to the petitioner for and booked the kitchen equipments. And he said that when he inquired, he found that the petitioner is not in the said business. Lordship, only this allegation is against the petitioner. And Lordship, the petitioner is doing the business. Yuvraj Steel Technology is a registered firm of petitioner, which was registered on 12th of August 2021. And the petitioner is working on this firm. After giving the quotations, and he is doing the business in the firm. Only, Lordship, petitioner prepared the booked item of respondent 2, and after that, the respondent 2 refused to take delivery of the items because his next booking with other customer was cancelled. Only this issue is happened between the both. And he's just harassing and
Who is appearing for anybody appearing for respondent number 2?
Yes.
Are you appearing?
I am appearing for.
Ready?
Yeah.
Are you ready?
Yes, I'm ready.
Yes. Yes. What is there? Anything is there?
Yes, this petitioner is not cooperating with
Doesn't matter.
investigation
Is there any
agency.
ingredients?
As many as 5 notices have been sent under section 35, subsection 3.
It's a quashing of praying for quashing of the fire. Is there any ingredients in the affair?
Yes, here in the petition is to
Where is the fire?
to quest.
yes, my lord. In petition page number 13, Lordship, in petition page number 13,
Who will read this?
please. Lordship, I, Krish Agarwal, at so and so, I have been running a business under name of Shri Rani Sati Agency. I came in contact with the accused, namely Salil Pandya, proprietor Yuvraj Steel Technology, who is in the business of manufacturing and supplying commercial kitchen equipments. Yuvraj Steel Technology is having its principal place of business in Kundli, Sonipat, Haryana. And as per the term of the said quotation, an amount of rupees 4,50,000 was transferred to the accused on 14th May 2020. It was agreed between the party that the rest of consideration will be paid at the time of dispatched items, that is on 30th of May 2024. On 28 May 2024, the accused contacted me and represented that the goods are ready for dispatch and that he is sending a e-way bill to me and further induced me to transfer the balance sole consideration as the goods were ready to dispatch. That believing the representation made by the accused to be true, I made another payment of 2,50,000 via cash deposit and further amount 2 lakh via RTGS on 30th May 2024.
Yes, where are you? Where are you now? Where are you, petitioner?
Yes, Lordship, please read the last para. That
Where is your agreement to supply? Is there any agreement to supply?
Yeah, agreement. I have exchanged the quotation and accepted by the respondent number 2. I prepared the item and items are kept with me till now. But he refused to take delivery, my lord, because his next order with the next party is cancelled.
Is there any agreement between
Yes,
you
my
and
lord.
the respondent?
Yes,
Where
my
it
lord.
is? Where is
Yes,
the
my lord.
agreement? Where is the agreement?
Agreement page 17, my lord. This is the quotation exchanged by the petitioner with the
Page
number 2. Page 17, my lord.
17.
Yes, my lord.
This is
And
not this is not an agreement.
Lordship, this is the quotation exchange between both. And page 18 at the last, this is the term conditions.
Yuvraj Steel is yours. Yours is Yuvraj Steel.
Yes, my lord. And page 18 at the last, term and conditions. Cartage and taxes extra are applicable. Payment terms 50% advance along with the confirmed purchase order and 50% balance on inspection in the factory. And they paid, I admit, my lord, they paid 9 lakh rupees to me. It's admitted. And I have prepared the booked item. And they passed the item, they confirmed the item. But when the order with the next party of respondent 2 was cancelled, they refused to take delivery, my lord. How can I send the item without the consent of respondent number 2? Then they filed the police complaint against me and pressurizing me to return back the money. My lord, I have invested so many money in the booked item. Now it's almost impossible for me to return the money back.
Why you are not joining?
Pardon, my lord?
Why you are not appearing before the police?
Lordship, actually, petitioner is the heart patient and petitioner has been ill for the last 2 months and continuously in touch with IO, and he has also submitted his medical to the IO also. Due to illness, he is not appearing, but he is continuously talked with the IO. And my lordship, I want to submit before honorable court, IO is also pressurizing the petitioner to come with 9 lakh cash and deposit to the police station, then he will settle the matter. And when petitioner asking for DD or check, he refusing the same.
Where is your statement to that effect? Where is your statement to that effect? That IO is asking to deposit 9 lakhs so that he can settle the matter.
This is the communication between the petitioner and IO on the last date, my lordship.
Where it is?
No, I have not submitted this statement before Honorable Court, lordship.
Huh?
This is not submitted before Honorable Court, lordship.
You file an affidavit to that effect.
I will file, lordship. I will file.
We're taking up next week.
Right, my lordship. But till then, lordship, kindly stay the police proceeding, lordship.
Sorry, we cannot stay. Where are you? Where are you? You are in Haryana.
I am Haryana, Sonipat, my lordship.
You come and appear before the police. We direct you to appear before the IO. All right.
Like lordship, kindly give me some protection, lordship.
You file an appropriate application for that. But you have to appear. You just cannot evade like this. Wrongly or rightly, there's an FIR. Right? A notice has been issued to you by the police. You are evading it. You appear. We'll consider the on merit of your this present petition. Am I clear?
Right, sir.
Am I clear?
It's okay, sir. It's okay.
You appear before the police. I'm passing an order.
But my humble request is to
No, you cannot evade like this. Law is very clear. You will not be arrested. You will have to. There's notice has been issued to you. You are
Okay.
making excuses of
Right,
illness
my
and all.
lord, I am ready to appear, but kindly pass an order and kindly give me temporary protection not to be arrested.
No, that we cannot. That we cannot. You file an appropriate application for that. We'll consider that.
Right, sir.
Yes.
So, my lord, since they are seeking
Appears
for,
to be purely out of civil dispute.
my lord,
You have asked for some kitchen equipment,
my lord, that is
materials.
what they have been projected.
And then according to
to-
them, they have given the quotation and they have, it's the material, the articles are ready with him.
To that
It's
extent, my lord,
purely your.
to that extent, my lord, this is true. But what
not-
happened, my lord,
You will
thereafter,
not be allowed to go for shortcut.
my lord, they supposed to send the kitchen item, but when the
It's a
final,
civil dispute in that
Madam-
case. Where's the question of, they are supposed to send, they are ready.
but till
He
today,
said, the petitioner said still with him, they are ready to give.
my lord,
Send it.
that is not there. My lord, still they are not.
Then where's the question of
ready.
420?
Connect.
Why you are not accepting it?
My lord, this is the policy statement. Since I am a purchaser, I am ready to accept. Since I have been insisting to get my
Yes,
material,
when you
that
are,
they have
you
never
deli-
tried to send.
when you will deliver the properties, the articles.
Lordship, I ready the articles on almost 30th May of 24.
You have delivered it.
Yes.
Have you delivered it?
No, no delivered, sir. They refuse to take the items. They refuse
Yes.
to take the items.
See, Mr. Modi is ready to deliver.
Yes,
You
I am
refuse
still
to
ready.
take the
I'm
articles.
today also
That
ready
is
to
it.
deliver the items, my lord.
If that is the case, it's purely a civil
Nah,
dispute.
This is, my lord,
If they want to
completely
take
what I
items
can
within
say the
7
wrong
days, I am
statement.
ready to
They
deliver,
have
my
never
lord.
tried to, my lord, dispatch. Even over the, my lord, we have made a chat between this, my lord, WhatsApp. Thereafter, my lord, when final payment was received, they supposed to, my lord, disperse the material by after 31st May
Now he's
2024.
ready.
Thereafter, my lord, we have been waiting for, my lord,
Now
another
he is
one.
ready. He is
Another
ready to
1 year.
supply and deliver.
But later, my lord, we come to know that he is even not a member of the Yuvraj Steel Technology, my lord.
Okay.
And thereafter, my
It's
lord, he was not there and he avoid and he is absconding and avoiding
Lordship,
me for
it's my
further discussion.
registered firm. I am there. It's my office, permanent office. I am doing the business, permanent business. So many customers are connected with me. I am not a fake traders and they have already doing business with me in 2019 also. They are not my first customer, my lord.
So
they are not dealing with me first time. This is the second time they are dealing with me.
Your Lordship, FIR in FIR serial number 5. Allegation in serial number 5 in the FIR. That may I read?
Yes.
In the FIR serial number 5. That till 31/5/05/2024, the accused was in regular touch with me. However, after taking an amount of rupees 9 lakhs on the pretext that the goods are dispatched and the same will be delivered at my above mentioned address, the accused is not traceable, and I am under strong apprehension that I have been cheated by the accused to the tune of rupees 9 lakhs. That in order to safeguard my money, I made inquiries and sent my representative to the address mentioned on the quotation issued by the accused, that is A23 Grand Port, Roman Court, near Parker Mall, Kundali, Sonipat, Haryana, and came to know that during the time of current transaction with the accused was not in the said business and had illegally forced himself.
Yes, Mister. Your last notice is 29/9/2024. You appear on that day. You appear before the police.
Right, my lordship. Kindly, I oblige my lordship. Kindly see the para 5 of affidavit filed by the respondent number 2. They already admitted all my version. Para 5 of affidavit filed by the respondent number 2 before the honorable court. Kindly see, my lord. Para 5, in which kindly may I read, sir?
We'll take it up next week. After a week, we'll take up the dispose of the matter on merit, but you appear on 29.
Right, my lord.
29 of this month before the police. And if you have some apprehension, I need not tell you, you avail the remedy, whatever is there.
Kindly see.
But appears to be prima facie civil dispute.
See para 5, my lord, please. Para 5 of.
He wants to deliver.
I want to deliver, and also, my lordship, I am honestly saying, you
tell your client, come with all those articles and deliver the same to the respondent on 28. And then 29 you appear before the police. And next week we'll dispose of your matter.
Right, my lord.
All right.
Right, my lordship. I request, my lord, kindly see para 5 of affidavit.
Learned counsel, where you are appearing from?
I am from Delhi, my lord.
So visit the state. It's a beautiful state. Along with your client. All right.
Right, my lord. Right.
Heard Mr.
Sandeep Dahiya.
Sandeep Dahiya, learned counsel for the petitioner. And also heard Jita, learned additional PP for the state, and Mr. C. Modi for respondent number 2. Next para. It appears that the police has issued a notice to the petitioner directing him to appear before, directing for appearance on 29/09/2024. List of. Mr. Dahiya, learned counsel for the petitioner, undertakes that the petitioner shall appear on 29, appear before the IO on 29/09/2024. Correct,
Right, sir. I will appear.
Mr. Needless to observe that the petitioner may avail appropriate remedy as may be permissible under the law. On the having considered the undertaking, by the learned counsel, Mr. Dahiya, for the petitioner, Mr. Dahiya, the matter shall, let this matter be listed on 03/010/2024 for final, for hearing, for admission hearing. We'll consider on that day. All right.
Right, sir.
My lord, let it be other day other than 03, my lord. Or
04.
04.
04.
Right.
But Mr. Modi appears to be purely civil dispute. FIR may not be. Privacy, it needs to be washed.
Intention is clear. He is evading from the police.
According to you, what do you say? Is there any ingredients?
Yes,
of
intention
formality?
that he is evading from the police. CD may be written. It may be reflected in the order papers.
Yes,
CD may be.
you retain it.
It
On
may be
fourth,
reflected.
fourth will take it up.
It may be reflected in the order.
You retain that. It's
Oh,
a scanned
what?
copy only, I think. It's a scanned copy.
Yes, it's can.
If it's a scanned copy, get the letter status on fourth.
Problems.
Because he said he will appear on 29.
Yes.
Okay, on fourth.
Right, sir.
Please.
We'll take up the other orders matters. Oh, this is orders is only 5. Huh? 13 to 15. We'll resume at 2.
Well,
Only we have 10 minutes to go. We'll take up other matters. Bail hearing.
Wait, Your Lordship.
Yes.
Your Lordship, on last occasion, the CD was called for along with the record of the earlier anticipatory bail. So as the earlier record is also not there, and moreover, we have even not received the case diary, Your Lordship.
Take it up day after tomorrow. Friday. You get the case diary and all those.
Your Lordship, the reminder to the registry because the record is before the court, Your Lordship.
Case diary has to be from the,
No, Your Lordship, so far as the record of the earlier anticipatory bail is concerned, it's a successive anticipatory bail.
all right, day after tomorrow
Yes, sir.
or Monday.
Day after tomorrow. Your Lordship, on 17, on 27 and 30, I will not be available here, Your Lordship. Otherwise, other PP will take up, Your Lordship.
Day after tomorrow, Lordship, because some difficulty is there.
What is the
Lordship, it was a case of theft. 370. 380 was put on me. My humble submission is a 381 October. The ingredients does not cover 380. That was my humble submission.
this is anticipatory?
Yes, Your Lordship.
Yes,
Some protection may be given, Lordship.
380, what is this 380?
Your Lordship, on earlier occasion, this court has cancelled the bail. Your Lordship.
What do we do?
Has rejected the bail. Your
I was the manager of the jewelry shop.
Huh?
I was the manager of the jewelry shop.
Okay.
Yes. So subsequently, I worked for 10 years. 10 years, my record was clean.
Stealing of gold
Yes.
ornaments.
And 380 is put, whereas 381, if at all, 381 is attracted. Provision of 380 ingredients is not attracted, Your Lordship.
Whether that will amounting to change in circumstances or not, that has to be taken
You
into
will
consideration.
grant bail and allow him to appear before the IO.
Please, Your Lordship. I'll appear.
Your Lordship, whether that will be change in circumstances or not, that
What
is.
circumstances? 380.
Because there is a order from this honorable court only on, they have annexed in page number 14, your lordship.
That is not, that is over, that submission will not hold water because the division bench of the, today, this court.
Had
has passed
Mr.
K.M. Mohan.
K.M. Mantha, learned counsel for the applicant, and also had Mr. T. at the learned additional PP. This court on, when is this? 16/09/2024. Has called for the case diary. However, Mr. T. at the learned additional PP submits that he is yet to receive the case diary. It is also noticed that it is also Mr. This court also directed this matter to be listed along with the records of AB number 32 of 2020. However, the records has not been taken good. Next period. In view of, let this matter be listed on Monday. 30/1/30/09.
Yes, your lordship.
30 Monday. So registry to place the take the records of AB number 32 of 2022.
First. Your lordship, let it be on first of September.
First, then first.
Obliged.
What I have informed regarding the record, I have inquired the registry. They say it is in sector, this, the earlier court. So they are not able to, sector.
Bring it, whatever is, bring it.
Please, Your Honor.
You also, and then the learned additional PP to produce the case diary.
Yes,
the
your
next
lordship.
day.
Again, will send it. Deeply obliged.
Interim protection.
But for some time, because there's a complication has been created by you only.
Also, the same finding may be
Because
given.
I have already made an observation whether this court has a doubt that whether can be considered as a successive bail application or not.
Lordship, that judgment I have,
That will decide.
that
That
judgment,
judgment you place on that day, not today.
some protection, Lordship.
There is. He has already left.
Please, Your Lordship.
Yes.
Your Honor, I seek some more time for filing reply in CRP.
Heard Mr. So-and-so learned counsel for the petition. Mr.
H.
Estai, learned counsel for the respondent.
In item number 7, I'm the respondent. And
Respondent number in item
all
CRP 73.
Yes.
37.
CRP 73.
Item 17
Item 17, Your Honor.
for respondent.
Yes, I'm respondent there.
Respondent number 17. Oh, sorry, respondent in the item number 17. That is CRP 37 of 2022. And petitioner in red petition 275. Is granted further 3 weeks time to file.
Obliged.
In this case, a small issue, my lord.
Hmm?
Whether the dismissal of the title suit, my lord,
Ah.
basing on the one document that was annexed in written statement, is valid or not. This can be disposed of today, my lord. Yes, other side also they have consented. They have nothing to argue this.
Respondent 1, 2, 3, 4, 5, 6, 7, and 14 and 16. So when the matter, it's they have disposed the matter relying on the written statement documents in this, and it's clear that with all fairness that the documents should have been properly validated to during the course of trial.
By taking evidence. There is a judgment of honorable apex court, my lord. Small issue, my lord. And other respondent, my lord, we
Why
have,
this is for listed orders who listed today, listed for orders today?
it is for orders, my lord. Paper
Why?
publication we have done, my lord.
Huh?
Paper publication we have done. The notice, my lord.
Then we'll complete that process first. Heard Mr. K. Tamalan, counsel for deputies, and also he gets you for respondent number
1, 2, 3, 4, 5, 6, 7, 14, and 16.
who else are not represented?
8 to 13, 15, 17 to 21. Last
8
order may kindly seen, my lord.
8 to 13.
Last order already expert is proceeded.
Huh?
Kindly see order dated 28/8/2024.
8 to 13, 15,
17 to 21.
17 to 21. You have taken by paper publication.
My lord.
The appellant has filed an affidavit showing the proof of
My lord, this will be repetition of the order.
Huh?
As per last order already, that is the 28/8/2024.
No, it's okay. The appellants have filed an affidavit. Affidavit. Bringing on record the paper publication for service of notice, for notice for respondent number 8 to 13, 15, 17 to 21, which is taken on record. Accordingly, the service upon respondent, the notice upon the respondent 8 to 13, 15, 17 to 21. Notice are complete. List for admission hearing after a week. After a week.
After a week.
Or after 2 weeks.
If
If he is conceding after a week.
After a week.
You are conceding?
Yes, Lordship, this.
Only legal experiment. Highly legal.
What is this?
Okay.
It's a recrimination petition, my lord, under section 97 of the Representation of the People's Act.
Yes.
Since the copy has already been served to the respondent, lordship may kindly take note of that. No further order is required to be passed.
Okay.
It is part of the move in the chessboard.
Yes.
Because under section 97, in an election petition, where there is a straight contest,
Yeah.
direct contest between the two candidates, and the candidate who loses the election, he files election petition. And there is a prayer in the election petition that in the event of election being held illegal of the returned candidate, there should be a further declaration in favor of the defeated candidate that he be declared elected. In such an eventuality, there is an option available to the returned candidate to file the recrimination petition.
Yes.
To the effect that in the event of election being set aside, even the election petitioner would not be entitled to get a declaration in his favor.
Yes.
So, my lord, it will come into effect, the recrimination petition, only after the conclusion of trial of the election petition.
Yes.
That is in view of the Arikila Narsu Reddy's case,
Okay.
2015-5 SEC. So, my lord, it will remain dormant practically.
So what is to be done today?
Nothing, my lord. Lordship may only take note of the fact that steps have already been taken. Copy has already been served to the has already been served to the respondent, and that's all, my lord. It will remain in the record. The main election petition is coming up on 27th.
You are for.
I am for the election petitioner. Sorry, I am for the respondent.
That's why I'm asking.
Yes, that's why the recrimination petition. That's why the recrimination petition.
Heard, Mr. It's here only, no, item 20. PKT only, learn senior counsel assisted by Mr. Learning counsel for the petition. oblique respondent. Mr. And also had Mr.
B. Tadar.
Learned counsel for the respondent oblique election petitioner, Mr. The petitioner oblique recruitment petition, you will be called a petitioner or the
We are the petitioner in the recrimination.
yeah, recrimination.
They are the respondent.
It's in the recrimination, item 20. The recrimination, the petitioner has filed the recrimination petition. A copy of which has already been served to the learned counsel for the election petitioner of the respondent. That's all. Then election petition,
It is coming up on 27th in any case,
27.
because the Lordship has had fixed the, yes, 27th it is to come up.
Okay, then
Again.
that's all. Then accordingly to me, so we'll pass election petition, we'll pass.
Yes,
separate
on
orders.
27th, Lordship, because my lord, we are going to file more applications in the meantime.
To be very frank, this code is very new to it. You have to,
My lord,
you have to properly assist.
certainly,
Sure.
and my lord, in any case, my lord, all of us are the learners, one way or the other. We learn every day.
Every day we're learning.
We learn every day. So that's perfectly okay. Because in the recrimination petition, nothing is required to be done. It will remain dormant till the conclusion of trial in the election petition. The earlier law was, the old law was that there should be a consolidated trial.
Yeah.
That is Basumutari case of our own High Court. But you know, the law changed after 2014-5 SCC, Arikila Narasimha Reddy's case. Because in that very particular judgment, the Supreme Court analyzed the past cases, including Jabar Ali's case. And then the Supreme Court said nothing doing. It is only after the conclusion of the election petition, in the event of election being setting aside, the recrimination petition is taken up. Thereafter, otherwise it remains dormant. In the Sanglu Pool's case, recrimination petition was filed.
But this code is determined to dispose of the election trial within 6 months.
Let us see, my lord, we'll all assist the honorable court if it is possible, certainly. The concept is, my lord, reasonable efforts have to be made.
Yes.
That's it. In any case, my lord, more applications are coming up.
That's where this code needs your
Certainly,
fair
certainly. We are all,
fair support and assistance.
my lord, fair support would always be there. Even if there is a legal precedent that goes against me, it will be placed before a lordship.
Try to maintain the sanctity of the
It would always be there.
trial of the election petition.
Certainly. It's from both the sides.
No, that's why I'm asking, not only.
It's counting the chickens before it hatches.
Yes. Next. Okay. Okay. What is this IA?
My lord, this is regarding delay in the filing of appeal.
1417.
Yes, my lord.
Office note dated 24/9/2024 reflects that service report is still awaited. Service report in respect of respondent number 1 and 2 has not been received back. Released after 3 weeks awaiting service report.
24.
In all,
my lord, 23, my lord, only in 25 also service report awaited. In 24, my lord, respondent number 1 has filed reply, but against 2 service report is awaited.
Have you taken fresh steps?
Yes, my lord.
Ever service reports in respect of respondent number two. Two. This after 3 weeks.
And in 25 also, my lord, service awaited in both the respondents as per office noted 24.
Ever service reports. This after 3 weeks. Huh? Any orders?
Yes, sir. Yes, sir.
Yes.
Yes, your lordship, yes, sir, we are on deposition of the PW1, your lordship. So according to us, your lordship, the statement of the victim is sterling one, and there is no any contradiction, your lordship. There is no any contradiction, and so far as your lordship, the contradiction is concerned, the procedure under section 145 of the Evidence Act has to be followed, your lordship. It has to be contradicted with the earlier one by repressing the memory of the victim, PW1, which has not done. So therefore, whatever she has stated is accepted to be true, your lordship. Your lordship may now directly come to, I will not, your lordship, the other or the deposition, most of the deposition has been read out by this appellant, your lord, convicted appellant, your lordship.
So you are relying on the PW1 only.
The other witnesses also, your lordship, I will come to that, your lordship. First, I will clarify, your lordship, the regarding the suspect bottle, your lordship, which was in question. So for that, your lordship may directly come to the judgment portion, wherein the learned trial court has a reasonable and comprehensive observation has been made on that. All their, your lordship, deposition has been reiterated and has been observation has been made on that, your lordship. Without taking much time, because if all the deposition has been individually, it will take more than an hour, your lordship. Your lordship, it will be better if we read para 26 to 38, your lordship, of the judgment.
Just wait, just wait.
Okay.
This page 27.
Yes, your lordship.
Paragraph 10.
Yes, your lordship.
Since I was carrying my so and so, he could not.
Thereafter.
So and so. Second time, she said he could not touch.
Your lordship.
Page 27.
27, yes, your lordship.
10, serial number 10.
Yes. Thereafter, he tried to drag me toward him by, this is the second time. Second time when she entered. First time, your lordship, it was alleged that he kissed and hugged and pressed her breast, your lordship. As I have, your lordship, indicated in para 6 was the first time.
The issue before the learned trial court. See, this is the point I raised this side.
Okay.
But I confess.
This then in that case we'll just segregate this petition. CRP.
This may be disposed of, then thereafter FA can be.
FA will not take along with this.
Yes.
After the disposal, we will take up this
Yes.
FA.
Yes.
In item 15, item 15 to we along with the IA. So your IA is you have raised all this, taken the point which you have submitted in IA. IA, which IA? 140, 114 and 118.
My IA,
Because there are three IAs, 3 or 4 IAs.
3 IA, my lord.
13, 14, you just write, heard so and so, so and so. List after 4 weeks, huh? Then you just remind those, as and when it is listed.
My lord.
This item 13 and 14, Mr. Sonar, we're listing it after 4 weeks.
after 13 and
13 and 14.
my lord.
After
13, 14, my lord, along with one more IA will be there, my lord.
you just find out.
114, my lord.
Are you sure?
My lord, may I check? Just check
Secret
the
and
report,
that,
my
because
lord.
we're segregating it.
Case record, my lord, just like this, my lord. 1114 is for either in the IA, 114, 118 is in the CRP, I think.
148, yes.
Just 118, my lord, this civil revision, my lord.
Okay. So you write in item 13, 14, huh?
13, 14 along with the IA 114, my lord.
114
My lord. This will be taken up together.
with the FAO, huh?
My lord.
Heard Mr. So-and-so, huh? Yetama, non-consumer appellant, and Mr. Arson, non-consumer for the respondent. List these matters after 4 weeks, huh? Both of you, the judgment.
It will depend consequence, my
Yes.
lord, after the judgment. If it
And
is
in
not-
item 15, huh? Item 15 along with 118.
My lord, 118.
Your IA is 118
My
in
118.
CRP. Huh? Item 15. Heard Mr. Yetama, land counsel for the petitioner, and Mr. Arsenal for respondent. Judgment, hearing concluded, judgment results.
My lord.
Maybe after 2 months. Because you have taken 2 days time.
Hello.
RCAB, judgment reserve. You just give your list of books, list of citations which you have relied. Okay. I think there's a mismatch somewhere.
Along with this particular sections and all.
No, not
Not
necessarily. You have taken that. I'll go through your petition. Because you may give new text, new facts also.
No, new facts I'll not get.
I'll go by your petition if you have taken all everything. You just give the list of the books.
Then citations.
Citations. Because it's I think misplaced somewhere. This CRP. CAB. This also.
Bibliography.
Citation along with the copy of the judgment.
Okay.
Because it's not easy to carry books. They will give the list. Both of you, huh? Both of you submit the list of books.
List
I
of-
mean this the copy of that.
तो वो कॉपी लोग को ये तो हम लोग लिस्ट बना के दे देगा ना. हाँ.
20? Yes. Kaliram Regon.
I don't know.
He's ready.
He was here.
Mr. Tara.
He told me that was want to do it.
Why?
I don't know.
Even if I don't hear you also, I'll keep it that reserve. I'll keep it CAB. Yes, till he comes, this item 28 and 29. No, just wait.
Yes. 29, my lord, I would like
It's
to
a four-
get, my lord, 28.
No, 4 months and 6 months, it's over now.
No, we're not inside the one bed.
Acha,
You
you are on bail.
Yes. 28 is a clear case where the alleged victim categorically says this is not the person who assaulted.
Hmm.
I was assaulted by the other person.
But you have a doubt in item 29.
29, I will argue in a
Different.
context. I will have to. This boy was 17, 18 more mopping now. He has in fact joined the bar now.
Then you enjoy the bail.
That's it. Otherwise, the Supreme Court is categorical. Once the prosecution enunciates two sets of evidence and what is contradicts each other, the petition has to go to this is in this case, it is not even a case of benefit. Unbelievable. Time and again, time and again. But I will not have easy
Because
to
that's
go
why,
to
that's because of this case only. 26, I have just said, make them, I ask them to cut it short. Otherwise, these, from,
It's a 30 years issue, man.
yes.
1991.
No, that's why.
The original claim, the two original claims is already there.
It's
The state is about to retire
See,
in 6 months.
otherwise also it's pending since 2016
Yes.
before this court. That's why. It's why I will have to hear it.
So can it be fixed tomorrow, my lord?
Call him.
They said he's not here.
Just call him. If he has really some difficulty,
Then I understand.
yes, that we can
Because
adjust.
the mention,
But
last of
yesterday he was represented by someone.
he told me that he will coming back on 24th, that is why 24 was agreed upon.
Yes.
Yesterday, only for a day, he said.
Okay, we'll wait for that. Then 28, 29, what is to be done? After vacation, if you are on bail. And otherwise also it's not possible today.
28, I would not have taken much time. I would even 10 minutes.
Now we'll take it up together. It's out of same judgment.
Yeah, but I would like to argue the other one in the different place.
Then do it next week, 28.
After vacation.
Oh.
The one may come and prayer.
Okay. 28 and 29, huh? You may segregate the time. PP is there.
Yes, yes. Miss Hagi said.
On the prayer of Mr. Deepangi, learned counsel to the petitioner.
Yeah.
Petitioners, list this matter after Puja vacation. MS L. Hage learned addition to P is present. Item 28, 29, huh?
Oh.
Yes. 26.
Well, yeah, I was occupied in court number 1.
It's okay.
So sorry. But it will take some time, you know.
It's okay. We're here till 4:45.
45 will be too.
My brother, the line runners.
My brother Pangin has been after this matter for long, and both of us has been accommodating each other.
Yes, 2016 matter.
Yes. So today I was under the impression that it might not come. So basically, Malad, this RFA is directed against the judgment and decree order dated 7/12/2015 passed in title suit number 7 of 2012.
7/12/2012. Judgment
15,
and order.
15. Pass in title suit number 7 of 2012 by additional district and session judge Pasigat.
What is the date of judgment?
Date of judgment is 7/12/2015.
7/12/2015.
Yes.
Okay.
Well, the case in nutshell. Seven in 77, the wife expired, and thereafter he was working in the procedural department as a demonstrator. Then he was transferred, he moved around, but somehow the defendant number 2 in the defendant number 1 sold the land of the defendant, of the appellant, who was pro forma defendant number 2. And thereafter the controversy erupted. And then in the meantime, the respondent in this case.
Yes, the land was given to the one purchase. Who has purchased the land?
Doctor father. I find out from here. All the things cannot be stored.
Plaintiff has purchased the land.
Plaintiff's father.
Huh?
Well, in this case, I'm trying to give the answer. That's
Yes.
what happened. The plaintiff father, he died. And thereafter, he was substituted.
Originally bought by that Tasim time.
Tasim time, yes.
Father-in-law of the present.
Present appellant.
Yes.
Yes. So then what happened? He was substituted by his son, doctor. He also died. I'll give you this. I'll take to this. Then what had happened? Then the doctor who substituted the father also expired. Then the wife has instituted this suit.
The wife is you.
And thereafter, what had happened? Earlier, this was
basically,
I'm yet
just wait. You are the plaintiff.
Yes.
Yes.
Okay.
I was a pro forma defendant.
Yes.
So then what had happened was, then this matter was once heard fully by the London FTC court, Basa. And then that judgment was assailed before this honorable court. This court interferes with and been agreed the plaintiff assailed the same before the honorable apex court. The honorable apex court thereafter set aside everything and remanded the matter back to hear afresh. So hence this title suit number 7 of 2012. 12. So there,
yes,
7 of 2012. So now what had happened? There were a lot of arguments. My brother Pangin was also there as a conducting counsel for the plaintiff, and Mr. Pertin was there. Now, my lord, the question that would involving is that whether the learned trial judge, while passing the impugned judgment and decree order, has committed a procedural error. 1. Whether, number 2, my argument will be on 2 things, two counts. Firstly, on the procedural error manifestly committed by the learned trial court, 1, while deciding this judgment, while passing this judgment and the decree. And number 2 is on the question of law, by placing the record. So basically, my argument would be on 2 folds. First, the procedural aspect. Secondly, on the question of law and the facts. So kindly come, other day. I'll not take much of the time. I'll finish it, because I'm also too fed up with this case,
You should not fed up.
No, adjournment after adjournments and a lot of time, and thereafter, just I have my written argument. Long back, some typological mistakes were also there, So before that,
It's there already.
yes, no, this is corrected 1 bit.
I have seen this.
Yes.
You have already submitted it.
So, kindly come to the impugned judgment, 25 to 70,
Page, so 25.
25 to 70, and then the decree is at 71 to 72. First, we go to the impugned judgment, page 25. Sorry.
Page 25.
CPC, where is our CPC? My lord will find at page 25.
Page 25.
Granted by.
No, it's not. Page 25 is some written argument.
One copy I it is. But my copy says, 25 to 17. My lord, last time also there was some confusion. The two set of RFA. No, this I'm on the correct copy.
I have the a copy of the judgment and order.
At which page, my lord?
No, this is in the front page.
Same page. Paper book, my lord, paper book.
Where's the paper book? Sorry,
Sorry, I also forgot to make the mention, my lord.
I have not seen any paper book.
There are two sets of paper book.
That's what, that's created confusion, my lord.
Page 25 would be the
Paper book.
here. Page 20.
Yes. After
My
this,
lord, the fact is we start reading paragraph 2, 3, 4 and 5 for the facts, my lord. 5 and 6. Then I'll make my submission on, my lord, the procedural aspect.
yes.
Pleaded case of the plaintiff is that the father-in-law of the plaintiff late Kasing Taing on dated 29/7/1984 purchased a plot of land measuring 1 pura situated at Tigra Mirmir Pasigat at the consideration of ₹6,000 from the defendant Sri Opak Rome since deceased. And thereafter, subsequently above named father-in-law of the plaintiff again on dated 23/6/1986 purchased another 30 feet of land adjacent to previously purchased land at the consideration of ₹1,000. And accordingly, the plaintiff in the present suit is claiming the title of the aforementioned purchased land. Defendant number 1, Sri Opak Rome, since this is who in his written statement admitted to have sold out the disputed land situated at Tigra Mirmir to the plaintiff, conducted this case in person and filed as many as 4 contradictory written statements on various dates. 3. The case of the 4 minutes. The case of the defendant number 3 is that sometime in the year 1975, my lord, this is important. The case of the defendant number 2 is that sometime in the year 1975, he purchased the present suit land from his deceased father-in-law, late Kodang Rome, at the consideration of ₹500. But on good faith, he did not execute any sale deed, and same was later on acknowledged by the sons of late Kodang Rome, namely this Kodang Rome is one who has sold this land illegally. Kodang Rome, namely Sri Opak Rome, Sri Oni Rome, and Sri Oi Rome. The defendant father stated that while the defendant were staying in the same land, his wife, late Yorak Rome, died in the year 1977. And therefore, in the year 1978, the defendant who was serving in Federal Department, Government of Arunachal Pradesh, was transferred and posted out to various places like Mariang, Yingkyong, and Jiro, and therefore he spent 13 years of his service life in those posting places. Defendant further stated that in those periods of 13 years, in 1978 to 1991, the defendant number one, Sri Opak Rome, since deceased who happens to be his brother-in-law, illegally sold out the present disputed land to the plaintiff's father-in-law, late Tasing Time, and therefore the defendant having came to know about the sale transaction laws, they complained on 30/10/1991. My lord, I just pause a moment and request my lord to kindly take on board these two particular dates, 1975 and 30/10/1991. Before Deputy Commissioner Pasigat, and accordingly, Kevang was held on two occasions on dated 19/12/1991 and 23/5/1992, wherein the Kavang authorities decided the matter in favor of defendant Kaliram Rigon, holding that the defendant number one, Sri Opak Rome, son of Lord late Kodang Rome, had no right to sell the sweet land. The said Kevang decisions and dated 23/5/1992 was confirmed by the Deputy Commissioner on dated 4/2/1993. Just I am pausing for a moment. In view of that, that have this apex court judgment for a moment. Because there it says
You are not permitted to take the
res judicata.
question of regime.
Yeah. So therefore that
So
has
it
been
goes.
set off.
Goes.
Set goes off. But
So we don't have to.
no, but
We
that-
don't have to remember 1975 and 1992.
no, but that is the germ of the whole issue.
Yeah.
From there, the fact is started. So therefore, my lord, the relevancy of the fact and the documents adduced therein will have a consequences in the form of evidence, my lord. So therefore, these aspects still remains. And therefore, the claims that since Kavang has already decided the title of the disputed land in his favor, same has attains its finality and nothing remains to be adjudicated afresh by the court. 5, my lord. This case reveals, the case record reveals that on the complaint lodged by the defendant number 2, Sri Kaliram Rigon, 2 Kavangs were conducted, one on dated 19/12/1991 and another on dated 23/5/1992. And in both the Kavangs, the Kavang authorities having found the sale transactions made in between the defendant number 1, Sri Opak Rome, and plaintiff late Tasing Time illegally decided the title of the present disputed land in favor of defendant number 2, Kaliram Rigon. That being agreed of the said Kavang decisions, the plaintiff Tasing Time since deceased filed a fresh suit before the court of Deputy Commissioner Pasigat for declaration of his title over his purchased land. However, he was later on substituted by his son, Dr. Talom Time, since deceased, and amended the plaint wherein the present defendant number 2, Kaliram Rigon, was impleaded as party to the suit after the date of late Talom Time present plaintiff. My lord, the serious question of law comes here. In the previous proceedings, my lord, all the proceedings, the first, my lord, will kindly have a flip back to page number 1, my lord, of the paper book. Here, my lord, I was a pro forma defendant. And subsequently, my lord, I'll place authorities on this matter at a later point of time. Now, if now thereafter the learned trial judge, my lord, says that the 29 issues were already framed. 29 issues were already framed, but he picks up 11 issues. Now, without filing
11 or 5?
11 issues, my lord.
11 or 5?
11, my lord, I believe.
I think 5.
Well, kindly see, my lord, which one he has instructed. My lord will kindly come to 7. There are 5 issues. Huh? Yeah. That during the pendency of
there are
yeah.
15.
Yeah. Yeah. 1, 2, 3, 4, 5. Now, my lord, the question is, once the trial has commenced, under CPC, all the issues has to be adjudicated because the issues have been framed with the consent of the parties. The court so moto cannot delete, omit, add any issues.
You'll have to go through
Yeah, no,
you
that-
read with the Supreme Court judgment.
Yes, yes, I have this. That I will place it, whatever my understanding and whatever my brother Pangin say, understands on the law, he will also have his own set of arguments. But fundamentally, what I am saying is, that once the trial has commenced, without any application, the issues cannot be deleted or added. There must be a proper application. The first fundamental mistake which the learned trial court has committed procedurally. There's a gross irregularity in the procedure.
Though 29 issues were framed.
Framed already.
Only the determination has been only for 5 issues.
5 issues.
Therefore, there is a procedural
Error.
error.
And second thing, Milord. Second thing is that once
The
you
issues were framed before or after?
before
After Supreme Court or before?
before Supreme Court,
5 after Supreme.
5 after Supreme Court, which he ought not to have done,
No. The 29 issues
were framed
By the
before by the deputy
before-
commissioner
before
before the
it was taken to Supreme Court.
Supreme Court. Yes,
After
that
it was sent remanded back,
right.
setting as an entire the decisions, including the first track, High Court, and Kebangs. Then these 5 issues have been
Framed arbitrarily without consent of the parties. This
no,
aspect-
there is no question of arbitrary in the civil proceedings.
well, this is illegality. Illegality.
Either illegality,
Procedural illegality.
either illegality or in contrary to the law. There is no question of arbitrary.
No, sometimes what happens, the definition of arbitrariness is too high. Suppose if a presiding officer, including ourselves, while making a decision,
It's an.
then what happens
it's
is,
a-
if he takes a prejudiced decision,
It's not a river. It's an ocean.
well, that sometimes we make window shopping in the castle of Chinatown. It's all like proverbs. In any case, so therefore, the first proposition what I am saying is, that once the issue was framed
Yes.
without consent of the parties, the presiding judge or the trial
Yes, sir.
court do not have the power. The trial court do not have the power to delete or amend the
Any issue.
any issues.
Issues
The
once
law
framed,
is settled,
once it is framed, you will have to determine every issue.
every issue, that is what exactly is the Order 6, Rule 17 of the CPC. That I'll come, I'll demonstrate
Yes,
that.
yes.
That is first thing. The second limb of my argument, before this, I'll be coming to the facts.
Hmm.
The second limb of argument, my lord, will also note it, is that I was a pro forma party
Hmm.
in the title suit. Now here, while Dr. Tang,
Hmm.
while filing a fresh application, title suit, without amending or filing an application, that is the requirement under Order 22, Rule 4 of the CPC, my lord. This was also a inappropriate appropriate procedural error committed manifestly by the learned judge. This part, I'll place the argument now.
Yes. So without amendment of the plaint,
Yes,
appellant was made dependent.
made as defendant.
Yes.
Now, on this first limb of my argument, there is manifest procedural error committed by the learned trial judge while conducting the trial and deciding the matter is perverse and gross illegalities under procedural law has been committed. Therefore, on this first leave of argument itself on the two grounds, this impugned judgment and decree is liable to be interfered with by this honorable court.
Two grounds only.
Yes, first on procedural part. On the merit, my lord. On the merit, I'll harp on one particular issue, my lord. Now, my lord will see. Then I'll come to those parts, my lord, except one important aspect I'll this put forward the argument, then now, my lord, kindly come to page 67, para 56 onward.
67.
67. Then I'll come to my written argument, then my lord, I'll finish, conclude, and place a judgment. In the result, the suit is decreed with following of reliefs. That henceforth the plaintiff shall not have right.
Shall
right,
have.
Shall have right. Shall have right.
That's you are here. That's you are here. If notice there, you are not supposed to be here. You would have been other side.
Probably the gracing age.
Yes.
Yes. That henceforth the plaintiff shall have right title over the disputed land measuring 1 pura, which is equivalent to 5,550.92 square meters, plus another 30 feet of adjacent land with the boundary described in the schedule. Permanent injunction granted, restrain the defendant and their employees, agent, etc., if any form encroaching over the sweet land in any manner, no order to the cause prepared. Now kindly come to this point. 71, my lord. 71, my lord. I'll indulge, my lord, kindly come to the defendant number 2. As I pointed out that without amending the plain, I have been made as defendant. Then, my lord, here, the perversity I'll point out from here, page 72. It is ordered that these title suit is decreed on contest that henceforth the plaintiff shall have right title over the disputed land measuring 1 pura, which is equivalent to so another 30 feet of adjacent land within the boundary described in the schedule. Permanent injunction granted, restraining the defendant. My lord, here, no, my lord, title, my lord. Just I'm pointing out, my lord. No title can be conferred unless there is a sale registered, because the land which purportedly have been sold has not been registered. Therefore, any land deed or gift for the sale which is not registered, no court can confer the title. Now, my lord, I'll come to my written argument.
No, sir, that will be too, you just establish.
Yes.
So as from for merit, what is wrong, in the evidence of the
yes, my lord, then
and the witnesses and the determination of the learned trial court.
Yes, my lord, now I'll come to my
Otherwise, it's very difficult.
Yes, my lord,
You are just showing that decree only, drawing of the decree.
correct, my lord.
That's
So,
would not be sufficient.
fundamentally, I have
I'll
outlined.
not be able to,
No, fundamentally, in a precise manner, I have outlined my line of arguments. My lord. I have made
no,
up. Now,
it's okay.
yeah.
If that
Now
is the
I'm
only,
coming to-
if you wish to choose to go that way, it's good for the court also
Yes,
to go this shortcut.
So
But,
therefore, my lord, now I'm coming.
that may not be sufficient.
No, that may not be. Now, therefore, kindly have my written argument, my lord, then I'll finish it off.
Yes.
My written argument is sufficient.
Written argument I'll consider, but then
Yeah.
see.
No, but my
But
written,
from
I'll
material-
place, I'll make my
From the
argument.
paper
I'll
book-
place it, I'll place
Yes.
from the paper book by relying.
Yes, you show and we'll come to the.
Yes,
this
yes.
thing.
But in my paper book only, I will indicate the pages.
Yes.
Yeah. But let us read together, my lord. If my lord has read also, kindly do not feel bored.
Yes. Okay.
My lord, before I pen down this written argument, para 2, my lord, I read. Kindly grant me leave to assert that my arguments would be on two broad aspects. Firstly, on the manifest procedural error committed by the learned district and session judge while passing the impugned judgment and decree dated 7/12/2012 passed in title suit number 7/2012, the part 1. And secondly, on the merit of the case, including placing of evidence orally, which are part of this RFA on next date fixed for hearing, that is part 2. Now the question is, part 1, Lord, whether the learned district and session judge, while passing the impugned judgment and decree dated 07/12/2012 passed in so and so, has committed manifest procedural error. My lord is kindly aware of the fact that the Code of Criminal Civil Procedure 1908 is substantive and procedural law. This observance of the rules of procedure is fundamental to the course of litigation, for they provide necessary framework for the achievement of justice between the parties. In the instant case, the learned district and session judge, while passing the impugned judgment and decree dated 7/12/2012 passed in so and so, on perusal of records, it prima facie discloses that there is absolutely non-compliance of Order 6, Rule 17 of the Code of Civil Procedure. In the context, it is apt to refer to paragraph 7, page 28 of the paper book, my lord. Kindly page 7. I'll show this way, my lord.
Yes.
There, my lord, just even I was not there even. Page 20, paragraph 7 of page 28. Wherein inter alia recorded by learned trial that the appellant, who was pro forma defendant in title suit number 3 of 1993, was impleaded as party to the suit. So that is what I have written. Page 28, no, I've seen.
Yes.
So now, a cursory, my observation, a cursory reading into recording at para 7 of the impugned judgment and decree dated 7/12/2012 passed in so and so, prima facie shows that no amendment application.
On a lighter note,
yes,
since you are dealing with the challenging the judgment and order of the trial court, you cannot have a cursory reading.
This happened earlier, that's how I
Yes.
don't want. This way, I don't will see. I have submitted the deleted argument only on 2 issues. that
You
are
cannot have a
cannot be
cursory,
argued like this.
cursory
No,
reading.
no, my lord,
I'll give you more, only give you more time. Forget about the cursory reading.
no, that's why word has wrongly been worded, you know, on perusal, on
No, no,
examinations.
Your written statement, I mean, submission appears, it is corroborates your submission, the which you have written.
Right. My lord, to be very fair side, I have dictated in 3 hours.
Yes.
One of my junior, I called up
See,
my
sir, I'll
junior,
tell
I
you.
dictated.
Let us learn together.
Correct.
This is a civil appeal. I think it's first appeal.
First
You are
appeal.
questioning the judgment and order of the trial court. We're on appellate jurisdiction. Since you are questioning and the validity, the correctness of the judgment, you'll have to go in detail.
Correct, that's why, my lord.
That cursory will not do.
No, it's not a cursory, my lord. First part, in this written argument, it
And
contains 2 parts.
Why not compel you to, this court will never compel you to argue what is, which you don't wish to. It's up to you. It's up to you. We cannot compel. But then, anyway, you continue. We'll see. In any case, we will not be able to complete today. We may continue tomorrow, day after. Sir,
I feel
you may.
for a lady, otherwise I will do the basic.
Madam, can we start
you
from
can-
first? From first we'll start and third and fourth we can conclude this.
Then tomorrow you can, tomorrow, day after.
I would not have, but I usually.
No, no.
But I have-
No,
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 you will-
whatever.
you will not
objection
take
comes
much,
from other
but
side, I
then
don't care. I don't
In
bother
any
also.
case,
But once
see,
I don't
in
finish,
any
then I
case,
should
in
argue.
any case, will not be able to complete today. Your part will also not be completed. We'll continue tomorrow.
Yes,
Yes,
day
tomorrow,
after.
no problem.
but this part.
Make it as a part heard. Then today is what?
Today is 24, 25.
25
25.
September 25.
And the judgment will be reserved.
Yes, yes. No, that 25. Can we resume from 27 and finish it off on first?
So
So
you
that
are- We'll continue tomorrow, day after.
Okay, I'll continue tomorrow.
26.
No, that's why, beloved, that my brother Pangin was saying that cursory, and because of this,
I said,
the
but
word,
I didn't want.
the word,
Cursory.
the
I said
cursory.
No, no,
the
this
word
is, that's why I
cursory does
say,
not
no,
mean
no,
that it
that's,
offends anybody.
see,
No, no.
Mr. Tara,
Yes.
this is, I said before that on a lighter note, I said,
Right.
you have used the word and you have read it, that's why I'm saying. On a lighter note, I'm saying, we're not compelled unless we find that gross, there will be a miscarriage of justice to the litigant.
Okay.
Will
Madam-
intervene.
Yes.
Otherwise, it's your, sole
Madam-
prerogative
Then, beloved,
to press which
Yeah.
the grounds you would like to press or which you would
Correct.
don't like.
Kindly
We are
allow-
not compel you.
Madam, kindly allow me to finish this part one.
Yes.
Part one, just it will
Yes,
take
yes.
another 5-10
Yes,
minutes.
yes.
I'll finish it
No,
off.
no, I said I'm here till
Se-
4:45.
Yes, second part, I'll start tomorrow.
Yes.
Yeah.
Okay. Page 28.
Page
Or are you reading from this?
Yes, I'm reading from this.
Okay, okay. Yes, continue.
Page second, my lord.
Yes.
Next page, my lord. Reading to recording para 7 of the impugned judgment and decree dated 7/12/2000 passed.
Roman 2. Are you reading Roman
No,
2?
page 2, my lord.
Page 2.
Page 2. Reading
Okay.
into.
Ah,
That I started from there.
ah.
Now that also we have read, my lord.
Which one? In the light,
Yes.
in the light of above.
From the above facts,
Ah,
from the above facts, it is discernible that the appellant was pro forma defendant in the entire lease, and no order was passed by the learned trial court, and thus no relief can be claimed by the plaintiff whatsoever. The coordinate bench of this honorable court in the case of Gurendra Das Laskar, my lord, kindly come to this, the black portion, my lord, highlighted portion.
which one?
Or
Page?
next page, my lord, second page of. My lord, that will be difficult, my lord. I have my another copy, my lord.
No, this is the,
That
this
is not
is,
a corrected copy, or a copy.
this is which you have supplied today.
Yeah, then.
This, I don't know. They're reading from this, I should be supplied.
I'll supply. Well, next page, second para. Next page, second.
That will be third page.
Right.
That will
Why
be third
something is
page.
going wrong with this?
That's what I'm saying. This is the copy you have supplied today.
Yes, yes.
In fact, I have read your earlier one yesterday.
Let me see, I'll check out. Well, one original copy was there.
And it is understood in the
Yes.
civil appeal.
Yes.
It will take time. I mean,
Which one?
Maybe we should restart.
let us not rush. I'll definitely will not rush.
Yes,
Even
yes,
I'm
yes.
yet to understand the facts. I think we'll continue tomorrow.
Yes.
It's better.
Tomorrow, but this same one. It's one and the same.
Same.
Yeah,
I
but-
think that is third one.
It is separate. I'll serve you.
So which you are trying to read that is page 3rd only, I think.
Page 3rd, yes, yes, we.
From the facts, it is discernible. It's this 3rd page only.
No,
Is not it?
From the fact.
There is no pagination also.
There is no pagination. This is
You
correct.
let us resume it tomorrow. You get it paginated by your junior and submit tomorrow. All right.
Correct, correct.
Should be. Heard Mr. T.T. Taran consent for the appellant and also heard Mr. Deepak consent for the respondent.
Number 1.
Respondent number 1.
No response. No, not so.
Hearing to continue tomorrow. We'll
Till
continue.
disposal, the interim to be continued, my lord. Till disposal.
We're taking it.
Yes, yes.
By day after tomorrow. We'll
Day
complete.
after.
27. Yes. When?
Some other day, my lord.
Huh? Huh?
Time constant.
After the.
But I think this is scared. We don't have to hear much on this. You have not been heard. Date was fixed, is not it? You have filed an appeal against the cover decision.
Yes.
And it was forwarded to Deputy Commissioner. Deputy Commissioner sent it back.
Send it to.
And hearing was fixed.
Yes.
You had some problem.
Yes.
You could not appear in the hearing.
Yes.
On the date of
Yes,
hearing. So the recent Deputy Commissioner passed the order. So what's wrong? Date was fixed. You didn't appear.
But there was a condition precedent.
Hmm.
On that very day.
Day after tomorrow. Or when?
Some other day.
Up to you. This I can dispose of.
This should have been a revision, but
Yes.
not an appeal.
You think over it.
It's a long pending case of.
Yeah, that's why I thought of you arguing. We'll hear maybe up to 5 o'clock. If you want.
Huh?
We can dispose.
Huh?
Otherwise, I am ready also.
I mean, you decide yourself first.
When I will make the prayer, my lord, let it be after the vacation. On my prayer.
After?
After the puja prayer.
Okay.
After vacation.
After vacation. On the prayer of landed council for the parties, Mr. D was a landed council for the petition appellant and Mr. D Pangi, landed council for the respondent. List this matter after puja vacation.
All right.
All right.
31, my lord.
This is what?
31, my lord. Just right, my lord. I'm sorry, I didn't bring the number. I will give it. There, this I have against the judgment and decree of the London Civil the Senior Division. I have come directly before this honorable court because the Arunachal Pradesh Civil Courts Act says either to the district judge or to the High Court. Does not specify anything. So, taking into consideration the analogy of the CRP 438, I have brought it. Now, Honorable Justice Subansyam, in some other cases, traded issue, whether it should come directly or have to go before the district judge.
Okay.
So, matter that will have to be decided.
Okay. In that case, heard Mr. D Pangi,
I'm sorry, I didn't
counsel
take the
for the
number. I'm appearing in that case.
appellant. Then in that case, you just give the list this matter along with that.
Yes, yes. I will give the case number.
No, in that case, you just on the prayer of Mr. D Pangi, sorry, Mr. D Pangi, London counsel for the appellant submits that similar issues in a connected matter. No, not Learned counsel for the appellant submits that in a connected matter, the issues involved in this appeal has already been framed by the coordinate bench of this court. Therefore, the matter may be listed along with the connected appeals.
Yes, sir.
You just give the
Yeah,
number.
I will give the number. I have to go back and think.
In view of the above submissions, let this matter be listed along with the connected appeal, RFA.
Oh, I will just find out from the registry. Yes, I will give it.
Connected matter being so and so, just keep it blank. Just give it.
I will just give it right.
No, that will be listed.
When it
along
comes, it
with-
will be listed.
Along with that connected matters. You give the number and you just.
Appeals, my lord, may say, because they have 3 appeals. I will give the number. Appeals.
Huh?